University. To the benefits of the audience, I will introduce Justice Maurice Kamga to all of you. So first let me tell you about his education and then about his professional experience. He has his bachelor's degree in public law with honors from University of Yaoundé, Cameroon in 1989. Master's degree in public law with honors, University of Yaoundé, Cameroon, 1990. Master's degree in international relations with honors, International Relations Institute of Cameroon, 1991. LLM in public law with honors from University of Yaoundé, Cameroon, 1991. PhD in international relations with specialization in diplomacy, cum laude with special commendation from the PhD committee and permission to publish. International Relations Institute of Cameroon, 1994. Certificate of participation, the Hague Academy of International Law, 1996, 2003, 2005. Diploma d'Etudes Supérieures in International Relations or specialization in international law, Graduate Institute of International Studies, Geneva, Switzerland, 1997. PhD in International Law, specialization in International Law of the Sea, Sharma cum laude, with special commendation from the PhD committee and permission to publish. Graduate Institute of International Studies, Geneva, Switzerland, 2003. Habilitation a rigor des researches in public law, University Paris Nanterre, France, 2017. Now I have the privilege of introducing some of the professional experience of today's speaker, Justice Maurice Kamga. He was assistant lecturer in public international law and in constitutional law, University of Yaoundé, Cameroon, from 1993 to 1995. Ministry of External Relations, Yaoundé, Cameroon. Integration as Secretary of Foreign Affairs, 1994. Counselor, 2006. Diplomatic Officer, Directorate for African Affairs, 1994 to 1997. Legal Advisor, 2003 to 2008. Minister Plenipotentiary since 2010. Intern as 9th United Nations Hamilton S. Emersinghe Memorial Fellow on Law of the Sea. Division of Ocean Affairs and the Law of the Sea, Office of Legal Counsel, United Nations, New York, United States of America, 1996. Associate Legal Linguist Officer, International Criminal Tribunal for the former Yugoslavia, The Hague, the Netherlands, from 1997 to 2001. Legal Publication Officer, International Tribunal for the Law of the Sea, Hamburg, Germany, from 2001 to 2002. Member of numerous Cameroonian delegations for bilateral or multilateral negotiations. Consultant at the Legal Office of the FAO, Rome, Italy. Missions in various countries in order to draft national laws on fisheries and aquaculture from 2001 to 2007. Adjunct Professor, International Relations, Institute of Cameroon, 2006 since present. Legal Secretary, International Court of Justice, The Hague, the Netherlands, from 2008 to 2020. Adjunct Professor, Catholic University of Lille, France, 2011 since present. Promoter and Executive President of HITAS, Hanseatic Institute of Technology and Applied Sciences, a private institution of higher education based in Douala, Cameroon, since 2021. And visiting lecturer professor at various universities and institutions, including Brussels School of International Studies, Belgium, 2005, University of Douala, Cameroon, 2012, World Maritime University, Malmö, Sweden, 2013, International Maritime Law Institute, Malta, 2013, 2015, and 2022, United Nations University, Maastricht Economic and Research Institute on Innovation and Technology, Maastricht, the Netherlands, from 2014 to 2019. Catholic University of Central Africa, Yaoundé, Cameroon, 2016. Kadir Has University, Istanbul, Turkey, from 2018 to 2022. Riz University at Brussels, Belgium, 2020 to 2021. Institut Diplomatique de Paris, 2020. University of Yaoundé, 2021. Director or co-director of numerous doctoral dissertations and member of thesis examination panels at several African and European universities since 2011. Member, Secretary General Association of Attendees and Alumni, the Hague Academy of International Law from 2011 to 2017. Founding member, African Society of International Law 2012 to present. Societe Francaise pour Droit International from 2015 to present. Dear friends and the privileged audience, we have the privilege of George Maurice K. Kamga visiting this university in the capacity of the executive president of the ITAS Institute. And we have also forged a memorandum of understanding between both the universities. And I am really personally honored and privileged to have my friend George Maurice K. Kamga as a distinguished speaker delivering this second SOAFAL 3 oration on the annual theme of integrated maritime studies. His topic is the ABC of the international law of the sea. Before the platform belongs to today's speaker, I will request our Vice Chancellor, if he is present, to just deliver his address briefly. Vice Chancellor, sir, are you there? Just let me check. Okay, maybe there will be some connectivity problem from his side. Okay, so now on behalf of the university and the outreach cell, I invite today's speaker, Justice Kamga, to deliver the oration. Sir.
Thank you very much. Thank you very much, Professor Sharma. It is a privilege for me to be invited for this conference. I was very happy to visit your university around 4 weeks or 5 weeks ago. And so thank you very much for inviting me. Good afternoon to the audience. So I was asked to speak about the topic of the EBC of International Law of the Sea. I hope you can see my screen.
We are able to see your screen, but not the PPT.
Not there?
PPT is not there.
What do you mean by that, please?
We are able to see you on the screen, but not
Yes.
the PPT. Please share the
PPT. Not the PowerPoint.
Please share the PPT.
Let me see. It should be here.
There will not be any problem. If there will be any issue, then we can share the PPT from our side. No issue.
Yes, please put it. I have some
okay.
small problem.
Bishant, please put the PPT. Bishant, please put the PPT. Please share the PPT. Yes. Okay. And make it full screen.
Full screen, please.
Make it full screen. Are you able to see the PPT?
I can see it.
Yes.
But not full screen.
Yeah. Bishant, please make it full screen. Oh, because it is in PDF format, so probably. Okay. Okay, you can proceed.
Okay. So, if I have to say something about the EBC of the International Law of the Sea, I presume that I give you some broad idea about the law of the sea, because it is a huge field of the international law in general. I presume that there are not many, or all the audience is not formed by only lawyers. So I'm trying to make it as simple as possible so that everyone will be able to understand. So, next screen, the world ocean covers some 70% of the surface of the Earth. And in order to have a broad idea, the next screen is the map, please. In order to have a broad idea of the international law of the sea, it might be interesting to start with some historical consideration. Initially, the oceans were used primarily for transportation of peoples and goods and the exploitation of fishery resources situated relatively near the major land masses. With the development of appropriate technologies, the range of uses of the oceans gradually expanded to include exploitation of living resources, the laying of submarine cables and pipelines, military use, the dumping of waste products from upland sea areas, recreation, and scientific research, leading to the expansion of knowledge about the planet and the enhanced use of other resources. As you know, whenever there are space and resources, the question of their ownership arises very quickly. Concerning the seas, the two main questions which arose nearly 1,000 years ago were the following. Who has the rights on the open sea? Second, who could trade there? The first attempt to answer those questions were made by Pope Alexander III in 1169 for the Council of Genoa. He declared that the principle of freedom is to reign on the seas, the freedom of the sea. In the second half of the 15th century, the great discoveries of Spaniards and Portuguese fired up a new competition for the sea control. It was then necessary to settle conflicts over lands newly discovered or explored by Christopher Columbus and other late 15th century voyagers. In 1493, after reports of Columbus' discovery has reached them, the Spanish rulers, Ferdinand and Isabella, enlisted papal support for the claim of the New World in order to inhibit the Portuguese and other possible rival claims. To accommodate them, the Spanish-born Pope Alexander VI issued bulls setting up a line of demarcation from pole to pole. About 300, next slide please, it was situated around 300 miles, 320 miles west of Cape Verde Island in Africa. Next slide, please. Spain were given rights to all nearly discovered and undiscovered lands in the region west of the line. Can you put this next slide, please?
Next slide, please.
Oh, it's not.
Bishant, please. Yes. Or no, this is not the. Bishant, the next slide.
The map. Not possible?
No, probably he is trying. Yeah. That becomes a big. Bishant,
Do you see my own plan, please? Hello?
yes. Now I
Can
am
you see?
able to. Now this is the slide, I think.
Yes, mine.
Right.
Okay. So I was saying that after, in 1493, after reports of Columbus' discovery has reached them, the Spanish rulers enlisted papal support for their claim to the New World in order to inhibit the Portuguese and other possible rival claimants. To accommodate them, the Spanish-born Pope Alexander VI issued bulls setting up a line of demarcation from pole to pole about 320 miles west of Cape Verde in Africa. Cape Verde is here. Can you see it? So this is the Africa. Can you see it, please? Oh, maybe. Hello? Professor Sharma?
Yes, Professor.
Can you see the map?
Yes. Please
Okay.
continue.
Okay. So Spain were given the exclusive rights to all newly discovered and undiscovered lands in the region west of the line. Portuguese expeditions were to keep to the east of the line. Neither power was to occupy any territory already in the hands of a Christian ruler. No other European powers facing the Atlantic Oceans ever accepted this papal disposition or the subsequent agreement deriving from it. King John II of Portugal was dissatisfied because Portugal's rights in the New World were insufficiently affirmed, and the Portuguese would not even have sufficient room at sea for their African voyages. Meeting in Spain, Spanish and Portuguese ambassadors reaffirmed the papal division, but the line itself was moved 1,185 miles west to the Cape Verde Island. So the second line was was made, and Pope Julius II finally sanctioned the change in 1506. The new boundary enabled Portugal to claim the coast of Brazil after its discovery by Pedro Alvarez Cabral in 1500. This treaty was the first attempt to define a geometrical boundary known as the Pope line. It divided unknown lands into a Spanish domain and a Portuguese domain. Hence, the Portuguese settled in Brazil and Western Africa, whilst Spaniards colonized the rest of South America, the Philippines, and many islands in the Pacific. In the meantime, during the 13th and 14th century, Norwegian, Danes, English, and Dutch controlled various parts of the North Sea and North Atlantic. Sporadic frictions occur between them in search of best shoals. In 1590, the Danes established an 8-mile strip around the shores of islands and declared it to be Danish waters. Similar strips were rapidly defined around all the possessions of the Danish crown, that is Norway, Faroe Islands, and so on. In the mid-17th century, Denmark extended the boundary to 24 miles. This was the beginning of a big legal and geographical debate from which most of the principles of the current law of the sea arose. The Dutch, a seafaring nation whose country has neither a long coastline nor any bays, were in favor of open seas. In 1609, the Dutch jurist Hugo Grotius published the well-known treatise Mare Liberum. Grotius, as it is also known, is considered to be the father of international law. So he published a treatise entitled Mare Liberum, the doctrine of freedom of the sea, which posited that no nation could validly subject any part of the high seas to its sovereignty, was based on the dual premises that the resources of the seas were inexhaustible and that it was not possible for nations or individuals to appropriate areas of the sea to their exclusive control. The British expert John Selden replied in 1635 with his treatise Mare Clausum, which championed the idea of the closed sea under the sovereignty of a power and restricted in terms of use by other states. Where Grotius then postulated the theory of open waters, Selden argued the theory of closed waters. Two schools of thought were in opposition. However, in late 18th century, the British backed out the theory of Mare Clausum, which did not suit their colonial expansionism and was detrimental to their merchant fleets. The new state of affairs increased the competition in the national appropriation of parts of the seas and their resources. Between the two world wars, a few states staked high claims of maritime jurisdiction. A major step were taken on September 20th, 1945, when President Harry Truman stated that henceforward, the United States of America had full jurisdiction over the resources of the continental shelf adjacent to their coast. Shortly afterwards, the United States started the offshore exploitation of oil off Texas and Louisiana. This fired up the rush on the high sea as the United States suddenly gained exclusive rights on 2.4 million square kilometers. All South American states unilaterally decreed the principle of 200 miles of territorial waters in the Santiago Declaration of 1952. This move was intended as a retaliation to the Truman Declaration of 1945, and it was imitated by some African and Asian countries in the coming years. As a consequence, the United Nations initiated two conferences in order to redefine the law of the sea and adapt to the new geopolitical situation. The first United Nations Conference on the Law of the Sea, UNCLOS 1, took place between February 24 and April 29, 1958. 4 conventions were adopted, but there was a major problem. The the state were unable to establish a maximum breadth of the territorial sea. A second United Conference on the Law of the Sea was held still in Geneva between March and April 1960. UNCLOS 2 did not result in any international agreement. The conference once again failed to fix the maximum breadth of the territorial sea or to establish consensus on sovereign fishing rights. It should be noted that the wide interest to the law of the sea was explained by the dramatic change in the political map of the world between the interwar period and the 1950s and 1960s. The evolution of international law of the sea was linked to that of the transportation techniques and maritime movement. Third world countries, including those without access to the sea, did not want to be left out the establishment of rules. Having neither a past nor a present in relation to the sea, they aspired to a future and had a numerical advantage. They also saw rules as a check on big nations' greed and a guarantee for weaker states. Even since the second conference held in Geneva in 1960, several third world countries has extended their jurisdiction on high sea, which constituted a favorable context for a third conference, as well as the divergent and contradictory interests could be conciliated. Third world countries were especially opposed to the mare liberum principle, the principle of the freedom of the sea, which, according to them, favor powerful maritime nations. They supported the mare clausum principle and put forward the 12 plus 188 idea, that is 12 miles for territorial waters, followed by 188 miles of economic patrimonial sea. So, at least 4 major problems concerning the use of the sea and their resources were at stake at the end of the 60s. First, with the development of sophisticated technology for the exploitation of petroleum and natural gas, resources from the continental shelf, a question arose concerning the seaward extent of coastal states' jurisdiction over such resources. The Convention on the Continental Shelf of 1958 was subject to varying interpretations on the question, and a concern developed whether coastal state jurisdiction could extend to mid-ocean, or whether at some point the international community at large, operating through an international agency, should possess rights to extract non-living resources from the seabed and the subsoil. Second, stocks of certain species of fish were being seriously depleted as a result of intensified catch efforts, coupled with the open access character of the high seas. Further, some coastal state fishery enterprises, such as those from the United States, were faced with increasingly difficult competitive efforts from well-financed and technologically superior distant water fishing states such as the Soviet Union, Norway, and the UK. The combination of stock depletion, potential economic deprivation, and other factors resulted in a number of conflicts involving fishing vessels, some of which escalated into violence. Third, the economic feasibility of mining metal bearing nodules from the seabed necessitated the development of some legal regime to govern the exploitation where the continental shelf jurisdiction of the coastal state terminated. Some felt that these mineral resources should be exploited for the benefit of all mankind, while many coastal states wishes to protect whatever economic interest they might have in such resources near their coast. Fourth, the international legal concept of innocent passage, by which both merchant and military vessels navigated in the territorial waters of states other than the flags which they fly, began to present some difficult problems of application. Some states wish to more comprehensively regulate the passage of foreign vessels for purposes of environmental protection and natural security, while the major maritime powers generally oppose the imposition of of any burden of navigation. It is with this background that we can analyze the new regime which was adopted at the end of the Third United Nations Conference in 1982. The conference took place between 1973 and 1982. It's virtually the longest conference at the United Nations. The so-called Montego Bay, or the United Convention on the Law of the Sea, also known as UNCLOS, was adopted in 10 December 1982 and came into force on 6 November 1996. It is one of the most popular international instruments in the world, as it has currently 168 state parties. Virtually all the coastal states of the world, minus some major actors such as the United States of America. The maritime zones recognized under the current international law of the sea, and which can be claimed by any coastal state, include the territorial sea, the contiguous zone, the exclusive economic zone, and the continental shelf. If we have a look, suppose we are on the plane and we can see downstairs, those will be the zones a coastal state can claim. In yellow, you have the land of a state, and we are here in the sea. We have what we call here a baseline, and after a baseline, a state can claim a territorial sea of 12 nautical miles, a contiguous zone of 12 nautical miles, an exclusive economic zone of 200 nautical miles, and a continental shelf of 200 nautical miles. You can have an extended continental shelf, and after that you have the high seas. This is a map you can see from upstairs. So we will see briefly the regime of this zone by having a look on this other map. Let us, the sea will start with the baseline. This is the baseline. Generally speaking, the normal baseline is the low water line along the coast, as marked on large-scale charts officially recognized by coastal state. So if you have a beach in your country, as you have it, when you're on the beach, normally the baseline is where the water will come and stop. That is the baseline. Before the baseline, you have the internal water. It is here. The internal water are the waters on the landlord side of the baseline from which the breadth of the territorial sea is measured. The coastal state has a full sovereignty over its internal waters as if they were part of its land territory. Example of internal waters include rivers, canals, and lakes. So the law of the sea will start with the baseline, and you have the territorial sea. This is the territorial sea. In old days, the territorial sea was 3 nautical miles. That was they call it the cannon shot. But nowadays, with the new international of the sea, the territorial sea can go until 12 nautical miles. Each coastal state may claim a territorial sea that extends seaward up to 12 nautical miles from its baseline. The coastal state exercises sovereignty over its territorial sea, the airspace above it, and the seabed and subsoil beneath it. Foreign flagships enjoy the rights of innocent passage while transiting the territorial sea, subject to laws and regulations adopted by the coastal state that are in conformity with the law of the sea convention. So in this area of the sea, territorial sea, it is virtually the sovereignty of a state, the coastal state. And 12 nautical sea is around 20 kilometers. So from the coast to 20 kilometers in the sea, the coastal state has virtual full sovereignty in what it is called the territorial sea. If you see very well the regime here downstairs, the regime is the regime of sovereignty. Then after the territorial sea, we have the contiguous zone, which is this zone. Contiguous zone, 12 nautical miles from territorial sea, plus 12 nautical miles of contiguous zone. Each coastal state may claim a contiguous zone adjacent to and beyond its territorial sea that extends seaward up to 24 nautical miles from its baseline. In its contiguous zone, a coastal state may exercise the control necessary to prevent the infringement of its custom, fiscal, immigration, or sanitary laws and regulations within its territory or territorial sea, and punish infringement of those laws and regulations committed within its territory or territorial sea. Additionally, in order to control trafficking in archaeological and historical objects found at sea, a coastal state may presume that their removal from the seabed of the contiguous zone without its consent is unlawful. So in the contiguous zone state, the coastal state will have some limited enforcement power related to custom, to immigration, to health, for example. And after the contiguous zone, we have the exclusive economic zone. Exclusive economic zone. Each coastal state may claim an exclusive economic zone, also known as EEZ, beyond and adjacent to its territorial sea that extend seaward up to 200 nautical miles from the baseline. So you will see that the contiguous zone is is included in the exclusive economic zone. Within its EEZ, a coastal state has 1. Sovereign rights for the purpose of exploring, exploiting, conserving, and managing natural resources, whether living or non-living, on the seabed and subsoil and the sub-adjacent waters, and with regard to other activity for the economic exploitation and exploration of the zone, such as the production of energy from the water, currents, and winds. The state will have 2, jurisdiction as provided for in international law with regard to the establishment and use of artificial island installations and structures, marine scientific research, and the protection and preservation of the marine environment. And 3, the state will have other rights and duties provided for under international law. So in the exclusive economic zone, in the column of this water, state will have some exclusive right, especially in terms of fisheries. The most important rights in the exclusive economic zone are rights relating to fishery. So a boat cannot come from the high sea and enter in an exclusive economic zone without indicating to the coastal state that we are coming, especially if it is a fishing boat. That boat has to indicate to the coastal state that we are crossing now your exclusive economic zone and we are not fishing. Because if the coastal state arrests that boat and discover that there is any fish in the boat, the coastal state can presume that the boat were fished in its exclusive economic zone. It is exclusive because no boat can fish in that zone without the express consent and authorization of the coastal state. That is the exclusive economic zone and its regime. And we have also the continental shelf underneath. The continental shelf of a state is comprised of the seabed and subsoil of the submarine area that extend beyond its territorial sea throughout the natural prolongation of its territory to the outer edge of the continental margin. So from here, you see this is the land. What it is in nearly yellow is the ground. So from here, we see how the land of the state is going through underneath the sea. After the territorial sea, then we have here the continental shelf, this area. It is then the natural prolongation of the land of the state into the sea until the outer edge of the continental margin. This is what generally in the sea they consider as the continental margin. Normally it will go further, but if the continental margin is less than 200 nautical miles, then the convention decided that each state will have a minimum of 200 nautical miles of continental shelf, whatever will be the configuration of the shelf. Okay? But if that coastal state is lucky enough that its natural prolongation is going further, then that state can have what we call an extended continental shelf, which can go until 370 kilometers maximum. 350 kilometers maximum. 350 miles from the baseline. So this is a normal continental shelf until 200 nautical miles. Some states have an extended continental shelf until 350 nautical miles. What is the regime of the continental shelf? A coastal state has sovereign rights and exclusive jurisdiction over its continental shelf for the purpose of exploring it and exploiting its natural resources, namely oil and gas. You remember we said that in 1945, the United States were the first state to claim the continental shelf and to start to exploit oil and gas on its continental shelf. So these are the zone, the maritime zone, which can be subject to the jurisdiction of coastal state. Beyond those zones, we have two international zones, which are the high seas on top, after 200 nautical miles of the exclusive economic zone, or the area after the continental shelf. If the continental shelf is after 200 nautical miles, then the area will start here. If we have an extended continental shelf, then it will start after 350 miles, the area. So the high sea, what is the regime? I can also show the other map, which can help you to understand better. Yeah, maybe. This is still more or less the same map. Here we have the extended continental shelf. We have the high seas here, and we have the area. So the high seas are comprised of all parts of the sea that are not included in the exclusive economic zone, the territorial sea, and internal waters. In the high sea are also open to the enjoyment of every state without any sovereignty, which shall be used for peaceful purposes only. So on the high sea, you have the freedom, the mare liberum, you remember, apply in the high sea. You have, for example, the freedom of navigation, you have the freedom of fishery, subject, of course, to some regulations. This is the high seas. Beneath the high sea, we have what is called the area, which is comprised of the seabed and subsoil beyond the limits of national jurisdiction. And it does not include superjacent waters. So the superjacent water belong to the high seas. The area is only the soil. Geographically, it is found at the outer edge of the continental shelf. The area and its resources are the common heritage of mankind. All this area, after the continental shelf, the area is considered nowadays, according to the 1982 Convention, as the common heritage of mankind. And no state may claim or exercise sovereignty or sovereign rights over any part of the area or its resources. Therefore, all the states and at the international level, which may be coastal or landlocked state, can access to the deep sea bed. The profits taken out of the utility of natural resources may be shared with the international community by the distribution if income of the international seabed authority regulates the area. So to make it clear, this area is under the jurisdiction of an international organization, which was one of the three organizations was created by the 1982 Convention. The International Seabed Authority, which is based in Kingston in Jamaica, is in charge of the exploitation and the exploration of the resources of the seabed. Actually, the exploitation has not yet begun. It will start virtually shortly in some years. And when the exploitation will take on, the profits will be shared among the international area, including even for states which are landlocked. So the benefit of the exploitation of the area will be divided between all states because, as I told you, that area is the common heritage of mankind. So I will not conclude my brief presentation of the law of the sea. I hope you understood something about those technical information, because law of the sea, some people consider it as very, very technical, but I try to make it as simple as possible. So I will not conclude my brief presentation about the international law of the sea without saying something about the issue of maritime delimitation. I don't just say that because it is one of my specialization. My second PhD in international law was on the issue of maritime delimitation. But it is because it is an important issue of international law in general and international law of the sea in particular. As we saw, the special distribution of jurisdiction of states is the foundation of oceans governance. In determining the special extent of coastal jurisdiction, a question that might arise is the situation where the jurisdiction of two or more coastal states overlaps. In this case, the delimitation of the overlapping maritime space is at issue. Maritime delimitation is, in fact, one of the most complex fields of international law in general and of international law of the sea in particular. To make it simple, let's say that the maritime delimitation is the process by which maritime frontiers are determined at sea, concretely, where the coast of two states are opposite one another or adjacent in such a manner that their maritime space, that is territorial sea, exclusive economic zone, or continental shelf overlap, then you need to make a delimitation. If you see on this map, we have state A and state B, for example, which are in opposition. If the distance between their coast, the two coasts, is less than 400 nautical miles, that means we will be obliged to make a delimitation of the exclusive economic zone and the continental shelf, because we say that the maximum measure of the exclusive economic zone is 200 nautical miles from the coast, and the maximum the continental shelf normally is also 200 nautical miles from the coast. So if you have a distance of 300 nautical miles between state A and state B, that means if the distance of the distance of the sea between them is around 300 nautical miles, it means that we are going to make a line dividing the two exclusive economic zone and the two continental shelf. If we use the normal line of equidistance, that is equal division, then they will have an exclusive economic zone and a continental shelf of 150 kilometers each. Then this line will be drawn after what we call a maritime delimitation, and it will form a frontier at sea. That line will not touch the territorial sea or the contiguous zone. But imagine if this distance was only 30 nautical miles. That means in that case, that this line will divide not the exclusive economic zone, but only the territorial sea. This is a case of delimitation with states in opposition. We can also have states where the coasts are adjacent. This is state E and state D. This is the land boundary between them. That means the land boundary has to be prolonged in the sea, into the sea. In that case, we have to make a delimitation of the territorial sea here in blue and the contiguous zone in light blue, and the delimitation of the continental shelf and the exclusive economic zone here. So when you have adjacent state, you automatically have to draw the line dividing the territorial sea, the contiguous zone, the continental shelf, and the exclusive economic zone. So depending on the geography, you might have several positions here. For example, you have state B and state C. You can see that B has an island here, which is very close to C. Then the maritime delimitation will follow this line, which will not be very favorable to C because of the presence of this island belonging to B. So maritime delimitation is also a huge field of the international law of the sea. I'll just give you an idea just to let you know that every state has the right to make a claim of certain maritime zone. In certain circumstances, those claims can overlap with the claim of another state. In that case, they have to proceed to a maritime delimitation, that is to make some line at sea. State can engage in bilateral negotiation or resort to a dispute settlement procedure in order to come to an agreement on delimitation. State can discuss directly between them and draw a line. They can also submit the case to a third party. For example, they can refer to the International Court of Justice. They can refer to the International Tribunal for the Law of the Sea. They can refer to some ad hoc arbitral tribunals which are created for the circumstances. Among those possibilities, let me say some few words about the International Tribunal for the Law of the Sea, which is one of the three institutions which was created by the 1982 Convention. The tribunal, also known as ITLOS, has its seat in Germany, in Hamburg, in the city of Hamburg. It is competent to deal with contentious cases between state parties to the convention, to the 1982 Convention. It is also competent to deliver advisory opinions upon request of some international institution. The tribunal is composed of 21 judges. The African continent has 5 judges. The Asian continent has 5 judges. Western Europe, 4 judges. Latin America and Caribbean, 4 judges. And Eastern Europe, 3 judges. That makes 21 judges. Nowadays, we have a female judge from India. We have now 4 female judges at the court, including a female judge from India, Her Excellency Nehru Chadha, who is a good friend of mine and who helped me to get in touch with your university. So with this, I say thank you very much for your kind attention, and I am available to some questions if you have them. Thank you.
Thank you, Professor Maurice. Thank you for such a brilliant talk on the ABC of the international law of the sea. Um, before asking any questions, I just have a request to make. Your deliberation on the is so comprehensive that I am tempted to ask you for the Word document so that we can translate it into our mother tongue, that is Odia, and we can submit it for a paper article so that more of the people will be familiar with the international law of the sea. Because during your deliberation, you have brought many facets of a sea also, the seabed, the continental shelf, shore, and many other things. So I think people should be very, very familiar with sea because the land's economy is being exhausted and a blue economy awaits for human future. So I just make a request to kindly mail me or WhatsApp me the Word document that you have prepared. So I will personally translate it into Odia and submit it by making it an article, a newspaper article. We can submit it for a wider dissemination. And
Okay, that is not a problem. I will send I will send you by next week.
okay. And the second request is because Her Excellency Niru Chadha is such a good friend of yours. I think sometime we'll also make a request to her through you to deliver one SOAFAL lecture on again on the international law of the sea.
No problem at all. I will convey. If you send me a message, I will just send to her.
Yes. Yeah.
I told her yesterday that I have to deliver a lecture in her country, and she was very happy.
Very okay. And we are actually preparing an architecture of the entire 25 lectures that are to be delivered on this particular annual theme of integrated maritime studies. So that finally, when all these 25 lectures will be compiled on different aspects of the sea, then I think it will have a reference value. It will have more self-life, and it can be referred not only by scholars, but by research scholars and general public also. So that was the idea behind introducing a specific topic as an annual theme. So now I think if anybody is there to ask a question, then they can ask, or otherwise I will take the liberty of asking a question to Justice Maurice. And now one question is, can you throw some light on the South China Sea conflict? My point is that though it is a very controversial topic, whether you can touch it or not is a different question. Because recently I had been to Vietnam, and they have that problems as far as South China is concerned. Actually, how the problem has originated, at least.
I'm very sorry. In my capacity, it will be very difficult to say a word on a burning issue.
Okay,
Yeah.
okay.
You know,
So,
that is
okay.
it's
I
difficult for
understand.
me. Yeah.
Then the next thing is that the exclusive zone for a particular country
Mhm.
up to which the sovereignty rights is claimed is how many nautical miles?
Yes, the exclusive economic zone, as I told you, is up to a maximum of 200 nautical miles from the baseline. That means actually it is 12 nautical miles plus 188 nautical miles. So it is technically 188 nautical miles after the territorial sea.
Okay. Now the
That is
next
the
question
exclusive
is,
economic zone.
okay. Okay, thank you. Now the next question is, up to the 200 nautical miles below the entire sea, that means starting from the level, the surface of the sea to the seabed, this also comes into the exclusive economic zone rights.
Yes, yes. The exclusive economic zone is on the column of the water and its resources. Everything in the water and the resources in the column of the water belong to the exclusive economic zone. And underneath, it is another regime, which is the continental shelf. That means after you have reached the soil, that is not the exclusive economic zone regime, but now the continental shelf regime, which is a bit different. Because, for example, a state has to claim the exclusive economic zone before it can impose that exclusivity. But concerning the continental shelf, the rights to a coastal state, to its continental shelf, exist ab initio, because it is considered to be the territory on the state underneath the sea. Even if that state does not make the claim, no other state can go there and try and start now, for example, to explore gas or oil. That gas of oil will belong to the coastal state, more or less as its territory belong to that coastal state.
Within another, my last question, is there any claims on the sea for a landlocked country?
No, normally not, because in the law of the sea, one of the principles is that land dominates the sea. So you can only claim maritime zone if you are going from a land. If from a land, from a territory. For example, if you have a tiny island in the middle of an ocean belonging to a state, that state will claim 12 nautical miles around the island, 24 contiguous zone, and then 200 nautical miles around the island. Can you imagine what will be the gain of a tiny island? But if you don't have the land, you cannot claim. So normally, landlocked cannot do anything at the sea. The only thing where they are concerned, and I say that, is that they have also the right in the area after the national, the maritime zone under the national jurisdiction. In the area, we say that the area is the patrimony, is the heritage, is the common heritage of the mankind. So it is for everyone. So when the area will be exploited, the benefit from the area will be shared among all the states, including the landlocked state. But a landlocked state can have its own boat, for example. A landlocked state has its own boat. It can have its own flat on the boat. For example, Switzerland has its own fleet which operates, even though they are landlocked state. So, but they cannot claim a maritime zone. They can enjoy the freedom of navigation. I say that in the high seas, the principle of freedom of navigation, the freedom of fishery on high seas. After the exclusive economic zone, then come the freedom of fishery in the high seas. So a landlocked state can also have a boat to go and fish there.
Thank you so much for enlightening on these questions. So if there are if anybody who has any questions, you can please ask. Or if you don't have any question, then on behalf of the university and the outreach cell, I am extremely thankful and grateful to today's speaker, Professor Dr. Justice Kamga, Maurice Kamga, for his kind deliberation on the ABC of the International law of the sea, and this series will go on. So I am extremely thankful and grateful to you, sir, once again. So thank you very much. Thank you.
Thank you very much.
Thank
Thank you.
you.
As I told you, I was privileged to be in your university. We really hope that we will have a full cooperation
Yeah.
for the training of young Africans, because
Exactly.
as I told to you, I came to your country in
Exactly.
in
We worked
December,
out.
and I came back in last week.
Now, just a little interruption. So the Vice
Yeah.
Chancellor has joined.
Okay.
So he will speak first.
Thank you. Thank you. Actually, I heard the entire lecture, and really it was very nice. So I thank George Maurice K. Kama for nicely explaining the international law about the sea, because this is a new topic, and nobody knows many things out of that.
Yes,
From behalf
yes.
of the university, I thank George Maurice K. Kamba to this SOAFAL series. Thank you, sir.
You're welcome, Mr. Vice
Thank you.
Chancellor. And as I was saying, I was at your university. I think it should be a model for the modest new private university in Cameroon. And I hope that we will really put in place a cooperation in order to help for the training of young Africans.
Definitely. Thank you, sir. Thank you very much.
Thank you.
Thank you very much.
Thank you.
Bye-bye.
Thank you, sir.
Bye.
Thank you for the audience. I hope
Yeah.
it was clear enough, because I know it is a very difficult topic.
But you have made it very clear. That's why I have a special request to you to kindly send the Word document so we can translate it into Odia for a larger dissemination. Okay.
I will do that. Don't worry.
Thank you.
Thank you.
Thank you.
And see you next time. Bye-bye.
Bye.
Bye.
Bye.